Any mention?
Yes,
Please, Your Lordship, I beg to mention item number 3.
yes.
I'm praying for 2 weeks' time, Lordship.
2016 matter. Why you are asking time repeatedly?
Lordship, Mr. GM, thank you, is not keeping well.
Your Lordship, I'm for the respondent number 1 and 2. I have no.
And how many respondents are there? No objection.
No objection, Your Lordship.
At the request of the petitioner, not objected to by the respondents, list of 2 weeks.
Much obliged.
Much obliged, Your Lordship.
Your Lordship, I beg to mention item number 10. Kindly let this matter come after 2 weeks, Your Lordship. No objection, Your Lordship.
When?
After 2 weeks, Your Lordship.
At the request of the petitioner, list of 2 weeks. Yes.
Oblige, Your Lordship.
May it please Your Lordship, I beg to mention item number 4, Your Lordship. Your Lordship, I'm praying for 2 weeks' time.
Why? These are old matters. Do not want
Yes,
to
Your
finish it.
Lordship.
This
The
2017
conducting counsel is still under treatment, Your Lordship.
Who? Mr.
A.H. Hasarka.
What happened to him?
Leg fracture, Your Lordship.
Your Lordship, I'm for the respondent number 1, 2, and 3, Your Lordship. I have no objection.
No objection.
No objection, Your Lordship.
Same order. Wait for weak petitioners, not objected to by the learned counsel for the respondents. Yes.
Oblige.
Oblige, Your Lordship.
May I please, Your Lordship, I beg to mention item number 2. This matter is pending before the division bench, Your Lordship.
What is pending before?
Before the division bench, Your Lordship.
This is why then? If this matter is pending before the division bench,
No,
or
this matter similar issues.
We have no objection.
no, there is no question of objection. What is the matter? What is the matter about here?
It's
Just
pertaining
land
to Asian
acquisition.
development ban. It is a land acquisition matter.
Yes.
We are asking for
Pertaining
fair
to
compensation.
Asian development.
Then what connected matter is pending before DVA?
It should be a similar matter which is connected with this matter. It is pending. It will have a bearing in this matter.
This has been recorded earlier.
Yes, Your
That
Lordship.
similar matter is
Yeah.
pending.
Yes, Your Lordship.
Just say learned counsel to the parties submit that connected matter pending before the DV having bearing in the present matter is yet to be disposed of. Stop. Paragraph. In view of the submission, this matter after 4 weeks.
Much obliged, Your Lordship.
May it please Your Lordship. Lordship, I beg to make a mention of item 5.
Yes.
Lordship, I'm praying this matter may come up after 2 weeks.
No objection, Your Lordship. The request of the petitioner not objected to the petition. List after 2 weeks. Yes.
Lordship, a similar prayer for items 7 and 8. These are connected matters, Lordship.
Same order. 7.
Same.
Yes.
Much obliged.
Highly obliged, Lordship.
May I please, Your Lordship? May it please, Your Lordship, I'm appearing. May it please, Your Lordship, I beg to make a mention of item number 12. I'm appearing on behalf of Miss Ardata, Lordship. She's having some personal difficulties.
A connected matter is pending to before DB, Your Lordship.
I'm praying this.
One personal difficulty. This also
No.
excuse me on behalf of one of MS Ardata, Learned Legal Aid Counsel. List is matter after
2 weeks, Lordship.
make it after 3 weeks. List is after 3 weeks. We have it after. You say it is a connected matter.
Yes, Lordship.
We'll have it after 3 weeks. Yes.
And obliged.
Lordship, similar prayer for item number 13.
13 who is the other side? Any objection?
We have no objection.
Same order this also. Yes.
All right.
May I please, Your Lordship? Lordship, I beg to mention item number 15, Your Lordship.
Item
15, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship.
I have objection to this.
This is matter regarding what?
This matter is regarding execution proceeding has been stayed by the executing court, and the matter is not
Can
proceeding.
this court take up the matter? This court had any role?
Yes, my lord, because I am aggrieved with the order passed by the executing court, who has stayed its own order.
I am asking whether this court can take up this matter. Was there any role played by this court before?
No, my
Not
lord.
very sure.
I am not aware, your lordship.
The name of the party.
Yes, I think, but I am not very much sure. But
anyway, right now, what is your prayer?
I have objection to this adjournment.
Kindly consider the adjournment, Your Lordship, for today.
But
This revision has.
But in this case, my lord, there is no role of this. In this particular case, there is no. But only maybe the name of the party.
That maybe we do not know. We'll just see it.
Yes.
Okay. What is your difficulty today?
The conducting counsel is on legs, Your Lordship.
So that cannot be ground for adjournment. We'll see. Let us see. Let us see. Let the matter come up. We'll just see.
Yes.
Much obliged, Your Lordship.
Please, I beg to mention item 18, Lordship, for the respondent.
Yes.
Praying for some accommodation to prepare the matter, Lordship.
What is this matter about?
So this is state appeal challenging the power of district council for anticipatory POCSO matter.
That anticipatory bail?
Yes, to the juvenile.
What is the problem?
I'm praying for 2 weeks for just preparing, Lordship. We can have it disposed on the next day.
No problem. Yes, sir. As requested by studies that I counsel the of the respondents. This matter happens.
Much obliged. Lordship, I beg to mention item 11.
Item
11.
Yes.
Since the conducting counsel, Mr. Advocate General, is not available.
What is the matter about?
So check gate matter, Your Lordship.
Check it. District council and state government, they are fighting.
Yes, Lordship.
Why?
Lordship, yeah, for the JHADC, Your Lordship. I'm appearing.
That is all right. But then what for JHDC has come here? Anyway, the request is made by Mr. Momin Learned G on behalf of the Advocate General is appearing here. Or I just say on request made on behalf of the state respondents. You have no objection?
No objection.
This is matter. After
2 weeks.
2 weeks.
Obliged.
May I please, Your Lordship? Your Lordship, I'll beg to make a mention of item 6. I'll beg to make a mention of item 6.
Item 6?
Yes, Your Lordship.
Yes.
Your Lordship, the arguing counsel is having some procedural difficulty today. Mr. Nombi is having some procedural difficulty today to argue the matter.
Could not follow, say it again.
Your Lordship, the conducting counsel, Mr. Nombi, is having some personal difficulty today to argue the matter.
Mr. Philemon Langri?
Yes.
He has personal difficulty?
Yes, sir. Yes, Your Lordship.
No objection, Your Lordship.
Sir, request to the petitioner, not object to the Delaware Council. This is not up. 2 weeks.
3 weeks, Your Lordship.
3 weeks.
Much obliged.
3 weeks.
Much obliged, Lordship. Your Lordship, I beg to mention item number 9, Your Lordship. The Learned Advocate General is not available today, Your Lordship. If this matter can come up after 2 weeks, Your Lordship.
Who is the other side?
Lordship, this is that matter where Shetty Commission recommendations were to be implemented. The question was whether the same issue is pending before the Supreme Court. On the last date, I had produced the order from the Supreme Court, which clearly showed that it was regarding service conditions of judiciary judges, not staff, because the subject matter of my petition is service conditions of staff. So AG was absent on the last occasion also. Today also is absent. It's a very small minor issue whether the same thing is pending in the Supreme.
But then
he can give instructions to his colleagues even if
2 weeks time may be given, Your Lordship. He'll be available, Your Lordship.
Let us see. Grant them some time.
Very
Your Lordship, another prayer, Your Lordship. If this matter can be tagged along with WPC 340 of 2024, Your
What is
Lordship.
that 340?
A similar issue, Your Lordship, but in 340.
Same council?
No, Your Lordship.
We'll see it later. Let
Okay,
it.
Your Lordship.
Just say at the request made on behalf of the Lord Advocate General, appearing for the state respondents. This is my record. 2 weeks. Yes.
Much obliged, Lordship.
Item number 1.
Yes.
We received the matters about this incident took place on 16/11/2024. In this case, last question put us that whether Union of India can refer this application. So this was the title for today.
Your Worship, actually, the conducting counsel in judicial is on her next.
Anyway, let us see what he has to say about that law first and
So
just
you will see here now. This petition is filed by the Union of India. Matter about elusive last question, we have pointed out this word elusive. That's as because named person is there in the affair, whether it is to be maintained. So, in my humble submissions here, elusive, if I give this Army Act, this is the special. This elusive. Section 125. May I read you, Lordship?
Yes.
Choice between the criminal code and the court martial. When a criminal code and the code of court.
That is a different thing. Taking over of investigation is a different thing.
So, Your Lordship, here in this, I am referring to.
You file appropriate application then.
Your
It
Lordship.
cannot be an application for quashing.
So, Your Lordship, just I am coming, Your Lordship. Why I filed this one?
You have cited a wrong provision, which is no application here.
So, Your Lordship, just because if it goes, Lordship, here in this matter, if we come to the even PNSS section 5, it will read together, Your Lordship.
At what stage this trial can be taken over? When can this court martial be claimed? When can court martial be claimed?
So here, Your Lordship, in this case,
Say when can court martial be claimed by the army authorities?
In one sense, Your Lordship, it is there if this any action is taken and charge sheet is filed, then we are having.
See what action army has taken in this matter? Do you just tell us?
We have taken the.
Have you taken any action here?
Yes, Your
Since you have cited 125, how you can invoke 125 here?
So, Your Lordship, here the provision I am showing due to this, Your Lordship, if any proceedings happen and then it will be taken by the army. So here in this case, Your Lordship, after incident happened, immediately after the incident happened, then we have taken cognizance. And in between the army persons therein. So it is not this individual
prayer
concern.
has nothing to do with 125. Your prayer is for quashing.
Yes, Your Lordship.
So we say that quashing application is not maintainable by Union of India. This quashing application is not maintainable by Union of India. Just address this court on that.
Otherwise, also, Your Lordship, if you go in BNSS, when this section.
What section?
Just I'm coming, Your Lordship. Section 218. Section 218, Your Lordship.
Section?
Section 218 of this BNSS, Your Lordship.
Yes.
Subsection 2, Your Lordship. No court shall take cognizance of offence alleged to have been committed by any member
Section
of the court. This 218 subsection 2. 218 subsection 2, Your Lordship.
Of?
BNSS, Your Lordship.
218.
218.
Prosecution of judges and public servants.
Yes, Your Lordship. In subsection 2.
Yes.
No court shall take cognizance of any offence alleged to have been committed by any member of the armed force of Union while acting on purpose to act in discharge of the official duty, except with the previous sanction of the central government. So, Your Lordship, when this person's name accused there is an official duty, Your Lordship.
That has to be determined. We cannot say that. And even if that there's a plea, that individuals will take, not Union of India. Anything more? 218 subclause 2. Then 125 Army Act. Anything more? What more you want to cite?
Section 5 of this. Savings to be.
Section 5 of?
BNSS.
That is common. That is CRPC also saying earlier. Savings. What it has to do here?
So you will say as because this the Union of India.
We are more concerned with how Union of India comes into picture here. We'll call for an affidavit from the secretary of this thing. That is better. How this has been filed. This has been filed on the basis of secretary, isn't it? Home Ministry, Defense of Ministry, Ministry of Defense.
Lordship.
Yes, I think. And who signed this petition?
It's signed by the unit officer.
Then we'll just call for an affidavit from this thing. Union Secretary, Ministry of Defense. That will be all right, I think. As to how Union of India files an application in a matter where some of the officials are implicated in a criminal case. That will be better. Yes?
That would be best, Lordship. On the point of locus.
But then here it's an application for quashing.
Lordship.
How can they seek quashing here? How Union of India seeks quashing?
Under the guise of saying that the state has no jurisdiction over them, Lordship.
No, but then that comes as a separate.
That comes later, Lordship. I will satisfy this Honorable Court's queries to that.
Because these are provision of 125, what Mr. Devnath has cited. These are akin to other provisions in BSF Act and all.
Lordship.
Same thing.
BSS, CRC, and then CIS is the same.
But Lordship, is quite surprising that for a 482 application, this has come from the ministry.
Now, what is your decision to take over the trial? What is the decision of Union of India in this matter to take over the trial? Where is the decision?
Your Lordship, already you have given this one, we have taken convincing order. Convincing order already you have included.
Convening order?
Yes, Your Lordship. Already you have taken that.
No, but then this is a matter you are seeking quashing.
So we are quashing for the FIR. Only for the FIR.
In the first instance, they are seeking quashing of FIR, Lordship. Second instance, they are questioning our jurisdiction.
Hard Mr. R. Devnath, Learned Counsel. appearing for the petition, and also MS NG Shinda, Learned Senior GA, Learned Senior PP
Lordship.
for the state respondents. Appearing with Mr. Yes, right. So the, just before just give a paragraph. By this application, the petitioner Union of India has sought for quashing of FIN number 2 of 25 dated 3/1/2025 under section 109 within bracket 1, section 117 within bracket 3, section 126 within bracket 2, section 337, section 239, section 61 within bracket 2, and section 35 of BMS 2023 registered at Umiam Police Station, District High Meghalaya. Sit down, just
Lordship.
stop paragraph. And the last petition on 25 to 2020, do not on the last petition on 25 to 2020, when this matter was taken up for consideration, this court has passed in specific order by taking note that since the concerned FIR has made allegation against certain officers in their individual capacity, how could the Union of India, represented by the Secretary from a Ministry of Defence, file this application under Section 482 CRPC? Stop. The learned CJC was granted time to place relevant law in this regard before this court. Give a full stop paragraph. Today, when this matter was taken up for consideration, the learned CGC has cited provision of section 125.
126.
Section 125 and 126 of the Army Act 1950 and submitted when a criminal court and the court martial have each jurisdiction in respect of an offence, it shall be in the discretion of the officer commanding of the army, in which the accused persons are serving, to decide before which court the proceeding shall be instituted. And if that officer decides that they should be instituted before a court martial. To direct the accused person shall be detained. Give after comma. After comma, then you say to direct that the accused person shall be detained in military custody. What 126 has to do with this thing? Subclause 2. What 26.1 has no application here? Further, the under CGC pointed out to process placed before the court. Or do not submit. Last further, learned CGC laid emphasis on section 218 BNSS 218 within brackets subsection 2 to content that no court shall take cognizance of an offence alleged to have been committed by any member of the armed forces of the Union while acting or purporting to act in the discharge of his official duty. Stop. The Honour CGSC as such submits that the instant criminal petition under section 428 BNS is maintainable before this court. Do you have any submission, madam?
Lordship, at this point, Lordship, your Lordship is disposing of the matter. If they
We'll dispose it.
Lordship, actually, my only point of contention is that in this instant case, the complainant and the accused are not from the same source. That is, one is Assam Rifles and one is the army. That's why the state has jurisdiction to Lordship.
The learned PP, senior PP, appearing for the state respondents, refused to submit it made by the CGSC and submits that the incident in relation to which this FIR is not this FIR, incident in relation to which the FIR was filed, had taken place in private place, and the accused named therein were not acting in their official capacity.
You will see my submission is there in official capacity. They are doing this official capacity.
Official capacity. The non-litigant further submits that matter is still under investigation. And it is premature at this stage to decide about the jurisdiction of court which should take up the matter. Jurisdiction of criminal court who should take up the matter. Stop. Before that, come to the first part of the Mr. Devnath's submission. Okay. In the beginning, you just say he submits that the accused name in the FIR were all in official duty. When the incident when the alleged incident took place. Okay. Give paragraph. Upon hearing the learned counsel for the parties and perusal of the materials on record. Where is the FIR?
FIR is at page 34, Lordship.
Yes. Okay. Yes, perusal of FIR dated 21 comparison the FIR dated 21/11/2024. No. Upon what is it? Comma. It transpires that FIR dated 21/11/2024 was filed by the private respondent number 3. Alleging no, this is not FIR. Is it FIR? This is not FIR. Page 34.
Page 34.
Oh, yes. Wait. This is dated.
Lordship, this is dated
14th
14th of December 2024, Lordship.
Earlier, what date we have taken? No, there is not. This should be 14/12/2024. FIR, huh? This is page 34 of the writ petition. Just page 34 and then subsequent pages you can see. What is it? Just think. That's fine. No, you don't have to say this thing. They say FIR dated. Alleging commission of physical assault and to attempt to take away his life by the persons named therein. Stop. It appears from the contents. You sit down, Mr. Devnath. It appears from the contents of the FIR that the alleged incident took place on the evening of 15th 11/2024 at, just say right within inverted comma, Cherry Blossom Festival 2024, comma, Umroi, Shillong. And the complainant as well as the accused persons were present there to attend the festival. Stop. There is nothing on record to show that those officers were on their official duty to attend the Cherry Blossom Festival. Stop. Give a paragraph. Perusal of provision of section 125 CRPC makes it clear that the provision relates to choice between criminal court and court martial. The provisions therein enables the officer commanding the army what is just sir last time. Two. decide. What we say? To decide, no? Decide. What does it say about the investigation stage?
Lordship.
So far as the investigation is concerned,
Lordship.
what happens in this kind of situation? Whether the question of court martial comes at the stage of investigation, or in the court itself, there is a court of inquiry is there. I think before a matter proceed for court martial, there has to be a court of inquiry.
Lordship.
And then court of inquiry has to be instituted.
Lordship.
This is in page 46, Your Lordship. Annexure 6, page 46.
Annexure 6, page
46.
Lordship, what the state is saying is that we have full jurisdiction to investigate into the matter, Lordship. We registered FIR and it's under investigation right now.
Yes, Bishop, please again. Just. As to whether the court of inquiry should be convened in relation to an offence committed by not committed, involving the officers of army, involving the officials of the army. And to decide before which court the proceeding shall be instituted. However, the provision therein contained, however, provision therein does not empower the army authority to seek squashing of the investigation already launched by the state authority. Any requisition has been sent to the court? Have you sent any requisition to the trial court demanding this matter be transferred to you? Any requisition?
There is
Nothing. There is nothing on record to show that any requisition has been sent by the army authority to the concerned criminal court. Under whose jurisdiction this incident took place. What is it? Just like you started with the requisition, what word? There is nothing on record, isn't it? Had we sent, not signed, sent to the under whose jurisdiction the alleged incident took place. That's all right. Just sit down. Even in the present criminal petition before this court, there is no prayer made for directing the concerned criminal court to the army authority directing the concerned, just say again, there are several. Yes. There is no prayer made in this petition for directing the for for direction for transfer of the entire matter.
But only the prayer was there to allow the competent.
The matter to the army authority. Instead, a prayer has been made for quashing the FIR. There is a provision probably in your own act to seek requisition, and if in the event the state claims that they should investigate the matter, then it should be sent to the central government for taking a decision. That is what the provision says. Come on, since the law does not give any, does not authorize the Union of India to seek. No. Since for taking over the matter, come on, the quashment of FIR is not repealed. Come on, this petition cannot be entertained. Stop. Cannot be entertained and accordingly stands dismissed. Stop. Then you say, despite the dismissal of the matter, the petitioner shall be at liberty to seek remedy in accordance with law prescribed in the Army Act of 1950. There will be a bit correction here there because this, probably these provisions are not.
My lord.
So this court was out of thing or
Any type of lodge.
just the thing is that what this court remembers, though, see like this, there's a provision definitely where they can seek, but the recusation has to be signed.
Lordship.
And upon refusal of the trial court, only then they can come to the court.
Lordship.
But not by 482 seeking quashing.
My lord, exactly.
And allowing them to do this thing.
Lordship.
There is nothing. Quashing stands for something different.
And also the question of locus, lordship. Much obliged, lordship.
That will be corrected.
Hearing item number 14.
May I please, Your Lordship?
Yes.
My apologies, Your Lordship. Due to personal difficulty of the conducting counsel.
What is the matter?
My lord, the matter is that your lordship execution uh, and a degree was passed for execution of the. And this is
You are
my
degree
lord-
holder.
Yes, yes, I am the degree holder.
Chief
The
Judge and
degree was
Judgment
yes,
Debtor.
yes.
You filed an execution.
Application.
It was filed within two years of.
Within 2 years.
Okay. Then
of the
what
degree.
happened?
So my lord, the executing court was pleased to order for execution of the degree.
Yes.
But before the execution could be completed, she passed another order, staying its own order.
On what ground that order was passed?
On the ground that there is a review petition pending.
So what is wrong about it?
My lord, the learned trial executing court has taken recourse of order 21, rule 26 of the CPC. My lord, first I will take your lordship to the order, which is in page 27.
This is what? This is a eviction of tenant.
Yes, your lordship. Yes, your lordship.
Page
27, your lordship.
Lord, if I
Oh,
can
yes,
make
Mr.
my
You are
lord,
there already.
if I can make a request, my lord, if this matter can come up tomorrow, my lord.
It's all right. See, your we have not refused prayer made by your
Yes, yes.
junior, but then just this court wanted to know what is it.
Yes.
Since there is an objection from.
Yes, yes.
My lord, I'll just this 29/7/2024 the order was passed. It is said that petition under order 21 rule 26 for stay of the execution order passed by this court on such and such is filed today. The averments in the petition. In your lordship, I have also enclosed the petition itself also.
Before that, where is the order of order?
Yes, your lordship.
For
Execution.
yes.
This is in page number 22, your lordship. Page 22.
Page 22.
Yes, sir. Yes. This says that your record put up today.
Yes.
So, my lord, in this by this order, the bailiff was directed to execute the degree in presence of the OC, and I was supposed to take the steps. I took the steps, and thereafter, your lordship, this petition, page number 23, was filed. Page number 23. It is filed under order 21, rule 26.
The ground was that review was.
Yes, only on that ground, your lordship.
Okay, so what is it barred under law?
Yes, your
What the
lordship.
order 21 rule
Order
26?
21, rule 26.
Yes.
Your lordship, I just read your 26. When court may stay execution.
Just a minute, Mr. Order 21 is very long.
Yes, your lordship. Rule 26.
It lays down on which situation your execution state, isn't it?
Yes, my lord.
Yes. When a court will consider. Yes.
Yes. The court to which a degree has been sent for execution shall, upon sufficient cause being shown, stay the execution of such degree for a reasonable time, to enable the judgment debtor to apply to the court by which the degree was passed, or to any court having appellate jurisdiction in respect of the degree or the execution thereof, for an order to stay execution, or for any other order relating to the degree or execution which might have been made by such court of first instance or appellate court, if execution has been issued thereof, or if application for execution has been made thereto. So, my lord, it says that the executing court may stay. on being sufficient cause shown only for the purpose to enable the judgment debtor to approach the court which has passed the degree or to the appellate court. In this case, Your Lordship, the judgment debtor has already exhausted the revenue, this avenue, like he has filed the review and the review petition is pending, and there, Your Lordship, prayer was made for stay of the execution which was not granted. The appellate court has refused, has not passed any stay, so they come subsequently, they came to the executing
They
court.
did not file an appeal, they have filed a review.
Review.
Yes, right.
So the
The,
petition
the,
is just
the,
give at the
the
appellate
degree
court.
was passed by the appellate court. Now, Your Lordship, they
Now,
filed the
the
review.
provision, what we could gather, is subject
Yes.
to,
Yes.
just correct. It says that the court can stay proceeding to allow a party either to approach the same court or the appellate court.
Yes, Your Lordship, which they have done.
Okay, for obtaining
Relief, a stay or something.
If they fail to do it, then
Yes.
execution should proceed.
Yes,
isn't it?
yes, yes.
That is what.
Yes.
Now you say that for them, they had already filed the review.
Already filed.
And the
No stay granted.
no stay granted.
Yes. So they came.
So that order, no order could have been passed.
Yes,
Stay
Your
order
Lordship.
could have
Yes,
been passed.
yes. That is
That
the
is your
only.
argument.
That is the only thing.
That is what you will have to encounter, Mr.
I'll argue the matter tomorrow, my lord, because as far as my
It will go to next week.
learned,
Tomorrow is-
yes, learned friend, whatever he has submitted, my lord, what he said is, my lord, we have filed a review. We have not preferred the appeal, my lord. So when we have not preferred the appeal, my lord,
Either an appeal or a review.
Or if-
You
yes.
see, let us see, let us survey these things. Okay, it's all only for the purpose of either to, you see, approach the trial court or the appellate court. Choice is yours. Okay, it should not be both.
And that is also
there
for-
should be two stay for two things.
Yes.
Just see this thing. Just look for some this thing, and we'll have it. In the,
Yes,
after a
yes.
week.
And that stay also for reasonable time, Your Lordship, not like when the limitation is prescribed for 30 days, 60
What
days.
is reasonable? It's very difficult to interpret.
Within the limitation period. Suppose if the review has to be filed within 30 days. If they want to go for appeal, it is 60 days. So within that period of time, the stay can be granted. Beyond that, it cannot be.
Now, once a review court refuses
Stay.
an execution, order
Subordinate
26
court,
order
Your Lordship.
26 rule 1 cannot be availed.
Yes. Subordinate court, how, if I will file before this honorable court, if this honorable court refuse to stay, then I will go and obtain from the learned trial court or subordinate court,
See, this basically stay is only for the purpose of
enabling
the
them.
judgment debtor to
Approach.
enable him to approach the court.
Yes, yes, that is the only limited purpose.
What that has been done,
Yes.
26(1) doesn't remain anymore.
Does not remain. That
Yes,
is the only.
yes, Mr. Sinkan will do it next week.
yes,
What-
my lord, yes.
Yes, at the request made by Mr. Sinkan, learned counsel acting for the respondent. This is matter after a week. That means I think that the small thing
Yes. And the execution court is also not proceeding ahead. Although this honorable court has not stay, but now that matter is also stuck. And for 9 months.
there is no interim order here.
No instance.
So,
So, but for 9 months, Your Lordship, after
no, but then
getting
you
the degree,
cannot blame this court has not given any interim protection to him.
but that court is not willing to proceed.
That is your failure. You could not convince.
No, I have pressed so many times, but the London trial court is saying that no, the matter is pending there, then I cannot proceed.
Item number 16.
After 1 week. Yes.
Well, this is a civil division application, my lord, against an order passed by the commercial court, my lord, in execution proceedings, my lord.
There is a provision for revision in Commercial Courts Act.
Well, we have come under 227, my lord.
There is no provision for
The CPC applies, my lord.
CPC applies. Now this is
The Commercial Court Act, under the Act, my lord, the statutory appeals are only against an order passed under Section 34, my lord, primarily, and apart from a few other provisions, my lord. So if it is, award is set aside by or upheld by under Section 34, then appeal lies to the division bench, my lord, under the Commercial Courts Act. Read with arbitration and conciliation, Section 37 of the Arbitration Act.
34 of the arbitration.
Yes, my lord. Section 34 is filed before the commercial court, my lord.
Yes.
Any order passed in Section 34 proceedings are appealable under Section 37 before the High Court, my lord. and that appeal is goes to the division bench, my lord.
And when a revision can be filed? And what
Apart from that, my lord, CPC applies under the Arbitration Act, my lord.
So why then 227 has been resorted here?
227 has been resorted to, my lord.
Is it not that 227 is not a regular power of revision?
227 is exercised in some circumstances.
227 comes when there is gross illegality proved by trial. If it is ordinary illegality, 227 can be. You see, it is not an alternative of 115.
That's true.
So why 227? Now, the problem is that, you see, I do not know what happens there, but then it is sometimes it is done purposefully by many parties, basically to avail jurisdiction of the High Court by skipping one forum in between.
Well, here that is not the case, my lord, because the order impugned, my lord, is passed by the commercial court, my lord.
But then is it say like perhaps there are decision by apex court,
my lord,
that is where statute stipulates provisions, 227 should not be resorted. Now, is it that the order passed, order which has been impugned here, we have no remedy
it's not
other
an
than that 227?
It's not an appealable order, my lord.
It's not an appealable.
It's not an appealable order. So the only way is to file a revision against those orders, my lord. Now the question that will remain is whether to come under 115 or under 227. That can be one question. But then again, the 115 does not lie against the interlocutory orders, my lord. That is.
Okay, this is an interlocutory order.
This is an interlocutory order, my lord.
Who is appearing for the other side?
For respondent 1, the decree holder.
Yes.
And on this matter, that 227, in order to come under 220 Article 227, the appellant has to prove that exceptional case, that there is a clear case of jurisdictional error in this case.
Unless jurisdictional error is 115 also is jurisdictional error. Same thing. 115 is all about jurisdiction.
Yes, and the other thing is manifest perversity. If they can prove that, manifest perversity.
So you can say that means that 227 is maintainable. There is no problem.
No, it's not maintainable in this code, Your Honor.
Why not? That is what we are asking. Now, if you say that jurisdictional error, let us see whether there is a jurisdictional error or not. Because if you say jurisdictional error, so far as this court understands, even 115 also is jurisdictional error.
And apart from that, Your Lordship, Section 8 of the Commercial Code Act, prohibits if there's a remedy, Your Lordship, they should avail that remedies. They cannot come directly to.
Give me a commercial court act. It is arbitration. Where is commercial court act? You have not given a list of books.
Your Lordship, I pray for some time, Your Lordship, to give the list.
Okay, so that is, you should have made that prayer before. After making half argument, you cannot. You are appearing, Mr. Gautam.
Well, I am the nodal agency of Assam Rifles. I don't have much to say here. I cannot directly oppose it.
You don't have much, or you do not have anything at all to say.
In fact, I don't have much in the sense that I don't have. The fact is that we float the tenders and then we undertake work on the business.
So otherwise you are not.
It's a performance.
So that is a fight between whom? And what is the original controversy? What is the?
Well, here what happened, my lord? An arbitration award has been passed in favor of the contractor, my lord, by the arbitrator. There, Mr. Wonsot is appealing for the contractor, my lord. I am appealing for Assam Rifles. Award was passed. We challenged the award under Section 34, my lord, before the commercial court. But that Section 34 is still pending before the learned trial court, my lord. Now, in the meantime, they filed an execution petition. Pursuant to the directions passed in the execution petition, my lord, we deposited an amount of the decretable amount before the trial court, my lord. And we requested the court that let the amount remain in the court. Because once it is released to the private parties, my lord, if we succeed in the Section 34, my lord, recovery becomes very, very difficult, and then court will ask us to file money suit, and so many things will come in, my lord. Now, that was rejected by the learned trial court. initially learned trial court said that you withdraw the money but give a bank guarantee.
Then what is the purpose of making a deposit then, if you do not allow the other side to withdraw it?
My lord, because in many cases court asks.
Is it not that the law has been framed that way, taking into consideration the interest of the recipient?
No, my lord, here what happened? Well, how to court can release, my lord, but by securing the amount, my lord. So initially, by first order, court said that ask them to give a bank guarantee and withdraw the amount. Then they filed an application before the trial court saying that we don't have sufficient bank guarantee, we don't have money, so allow us to take the money from the court on giving an indemnity bond, my lord. Now, indemnity bond is something like an affidavit, my lord. That does not secure the money, my lord. What trial court is done, my lord?
It's only kind of undertaking.
Undertaking, my lord. So that is
so
not.
That remains whether you give it or not. Once legal liability is there to refund,
my lord,
no additional undertaking is needed. If you are successful in your case, then they will have to refund it, isn't it?
But my lord, what happens normally? If we succeed, my lord, after court releases the entire money to them, and then we succeed in appeal, my lord, we will.
Is there any law which says that in such a situation money should not be released?
But money can be, our only case, my lord, the court should secure the money, my lord, by asking for bank guarantee.
Which way? If they do not have insufficient funds, if they do not have that guarantee of that much, then what happens? Is it that if they cannot provide adequate security, money cannot be released? Is it the law?
Well, in my humble submission, it cannot be that way.
If you
court
say
is
that,
direct.
you have to satisfy us. You see, like this
I'll
court is putting you
satisfy.
query. This court doesn't know anything about that. So it is only totally dependent upon whatever you say. Now, whatever the query is coming to the mind of the court. So normally, you see, like the provision of making the deposit is basically
for staying the execution proceedings, my lord. So if we deposit some money in the court, then execution proceedings are stayed, my lord.
So that is taking into consideration the interest of the
my lord,
other side, isn't it? Now, whether that purpose can be defeated by bringing in all those things in the name of security, or if you have an apprehension that in the event you are successful,
because my lord,
become very tough.
Because my lord, the amount is not crystallized fully.
Then that very
it is sub judice, my lord.
That very
matter is sub judice.
Which requires deposit, that becomes that provision becomes useless.
And especially because the section 34 is pending before the same court. But here what happened, my lord, the learned trial court has given too much of emphasis on the execution part, my lord, and less emphasis on our appeal, section 34. If we lose section 34, my lord, the entire money will go to them. We cannot stop that, my lord.
Anyway, when?
After a week, after a week.
2 weeks.
After
2 weeks.
You'll have to place everything before this court, Dr. Majika. This court has no idea about arbitration, commercial courts, everything.
I'll try to place one.
But then there will be a lot of query from the court, definitely.
Well, I understand.
That you have to come across. Well, and what would be correct position we will decide only after you place before the court. Okay, just the request made by the learned counsel for the respondent, not objected to by Dr. Majika, learned DSG, list this matter after 2 weeks. Yes.
Item number 17.
Again, matrimonial matter?
No matter.
This court has difficulty in handling matrimonial cases. Yes, what is this?
Well, a limited question.
You have changed side.
Yes. Well, my written statement was closed, and in the ground given by the learned trial court, my lord, is that 90 days period is over, and my contention is that 90 days are not over.
Is it? It's a matter of simple arithmetical calculation, or
a simple matter.
Yes, Mr. Shan, is it correct?
You know, what has happened is on that date when this matter was listed, we had appeared, and in fact my colleague had made an inquiry from the bench assistant whether 90 days is expired. So they informed us as 90 days is expired, so I made that submission. I thinking it was responsible, I had made it.
What is the fact? 90 days.
We are yet to ascertain because this was served on them by the process server. Now, what's happened, my friend is also not very certain.
What the law says, 90 days from which date?
From the date of service of summons. From service of summons. And the thing is, he's saying on or about 30th of August 2024 is when they have received it. They're not very certain. If Lordships permit me a day or two, I'll just ascertain from the process server.
For calculation, if it is 90 days is to be calculated, that is the only issue. Then we must know the exact date.
Exactly. Otherwise, I have no difficulty.
You also do not have any information. Now, you may not have, but then it will be available.
We'll inquire. Because even he's not very certain. He's saying it's around on or about 30th. Not very certain. I'll inquire from the process server.
Not very certain.
But the court, my lord, has recorded 30/8/2024. But I think inadvertently has recorded that 90 days is over, which was not over as on that date.
He will not be that certain because he will have to overcome that hurdle of 90 days.
90 days. Well, but if my lord comes at page 86, my lord, the last page, my lord, the court has specifically said that 90 days are over, my lord. And my learned friend is conceding that on that particular day, 90 days were not over.
No, I'm not conceding that. I was informed by the bench.
He doesn't know the information, the basis on which he made the submission. That was correct. That is what his submission.
So we made an inquiry. We were told. I have not actually seen the report of the.
You just both of you just verify by yourself. It should not be something like that. The one side comes with one thing. The other
Exactly.
You verify by yourself, and then we'll have it after 1 week or 2 weeks, whatever you say.
Yes. 1 week, not because then at least my trial can progress. 1 week then.
Okay. Just at the joint request made with the parties, this is matter after a week. I'll have it after a week.
Deeply appreciated.
You send that file. That matrimonial matter.
My lord, it may come up after 2 weeks, my lord. Next week I'm on medical leave.
Fine. No problem.
2 weeks. Make it 2 weeks. This one. Medical leave for yourself.
Oh, I have to undergo a surgery, my lord.
What surgery?
Nasal deviations, my lord.
Polypus.
Polypus, a number of them, my lord. There will be 3 surgeries at one go.
Where you will be doing it?
Bangalore, my lord, most probably.
2 weeks will be enough. You can come back by that time. Anyway, let us see.
Somebody else will. Yes. Deeply appreciated.